Okay, so just to get the other technical issues sorted, if I guess we could start with the appellants just to say a few words to make sure your mics and cameras are working properly, and then the respondents, and then the judges.
Hi, I'm counsel for the appellant, and I'll be presenting our first submission, and my name is Zara Shirur.
My name is Salman Abbasi. I'm co-counsel with Ms. Shiri and will be presenting submissions for the appellant.
Hello, I'm Zara Shirur, and I'm here with my co-counsel and will be providing submissions for the respondents. Thank you.
This is Levon Meridian. Me and my co-counsel Zara will be arguing for the respondents.
And maybe Justice Panel, Justice Penty, Justice Vision Bolden, and Dr. Cameron.
Justice Peter Pomel from the federal court. I'm delighted to be here.
Justice Bill Penty, federal court, the same. Welcome.
And Zara Shirur, federal court as well. Happy to be here.
I'm Hilary Evans Cameron from the Lincoln Alexander School of Law. Delighted to be here. Thank you.
Before I open the court, can I just confirm that both sides will be splitting their time evenly? Or are you splitting your time differently?
For the appellant, oh, sorry. Oh, sorry, go ahead.
So Michelle, just before we open that, I'm going to do the introductions.
Okay, great.
Start, okay? Okay. Okay, so good afternoon and welcome to the final round of this year's Immigration, Refugee and Citizenship Law Moot. So my name is Cheryl Robinson. I'm a member of the lead committee and also a co-chair of the content subcommittee. So that's the committee that produces the moot problem each year, as well as the bench memo that the judges work with. And so I'm hoping very much that mooters and judges alike enjoyed the problem this year and the novel issues that it raises for refugee law. So I know we've done a few preliminary introductions, so I'm just going to follow up and introduce as well as congratulate the 4 mooters that join us for the final round. For the appellants, we have Team 50A, that's Kimia Shiri and Salman Abbasi. And for the respondents, Team 20R, which is Zara Shirur and Levon Meridian. So congratulations again for making it to the final round. That's amazing. And good luck in the upcoming round as well. So also on your screen is the judging panel for the final round. And this year we have 4 judges. So to begin by way of introduction, Justice Penty is with us here today. He was appointed to the federal court on June 23rd, 2017. He holds a BA from Queen's University, as well as an LLB and a master's in public law from the University of Ottawa. Justice Penty was a professor in the Faculty of Law at the University of Ottawa and subsequently joined the Federal Public Service, where he held many roles, including Deputy Minister of Justice and Deputy Attorney General of Canada. Next on the panel, we have Justice Pomel, who was appointed to the federal court on May 2nd, 2019. And after completing his Bachelor of Commerce from Concordia University, he obtained Bachelors of Civil and Common Law from McGill University. He subsequently joined McMaster Meehan and was part of the shipping law group at BLG in Montreal, where prior to his appointment to the federal court, Justice Pomel was one of the leading Admiralty lawyers in Canada. And to round out the trio of federal court judges on the panel, we also have Justice Reginbold here with us today, who was appointed to the federal court on October 7th, 2022. He has an LLB from the University of Ottawa and a Master of Laws from Oxford University. And prior to his appointment to the bench, Justice Reginbold was a member of the Ontario, Quebec, and Nunavut bars. He has clerked for Justices Rothstein and Major of the Supreme Court of Canada, has worked for the Department of Justice, taught at the University of Ottawa, was a partner at Gowling WLG, as well as the author of several administrative and constitutional law publications. Our fourth judge is Professor Hilary Evans Cameron. She is not a federal court judge, but rather is an assistant professor with the Lincoln Alexander School of Law at Toronto Metropolitan University. She holds a BA from McGill and LLB from Osgoode, has completed doctorate studies at the University of Toronto, and as a former litigator represented refugee claimants for a decade. And during that decade, she was also an immigration lawyer at the University of Toronto's clinic, Downtown Legal Services, where she supervised many students, including myself, which I'm sure was a highlight of her career so far. And Professor Evans Cameron is also the author of an incredible text regarding the process of judging a refugee claimant's credibility. That's named Refugee Law Laws, Fact-Finding Crisis, Truth Risk, and the Wrong Mistake. And I would strongly encourage everyone to review that text because it is excellent. So welcome all to the final round. We obviously have an incredible judging panel and mooters for the final round, so it's going to be very exciting. And at this point, I'm going to turn everything over to the registrar so that we can start the hearing.
Sorry about that. Great. So just before I open the court, could the appellants and then the respondents just confirm the order and the time that you'll be using?
Yes, I will be appearing first and I'll be using 25 minutes and my co-counsel will be using 20 minutes.
Hello, I will be appearing first and I will be using 25 minutes and my co-counsel will be using 20 minutes. Thank you.
Thank you so much. This special sitting of the Crown Court of Canada is now open. Cette séance spéciale de la Cour de la Couronne du Canada est maintenant ouverte. Welcome to the final round of the 2023 Immigration, Refugee, and Citizenship Law Moot, where Appellant Group 50A will be appearing against Respondent Group 20R. Bienvenue au dernier tour du concours de plaidoiries portant sur le droit de l'immigration, des réfugiés et de la citoyenneté, où l'équipe de la partie demanderesse 50A comparaîtra contre l'équipe de la partie demanderesse 20R. I would like to recognize that we are all attending this event virtually across Canada and invite you to acknowledge the traditional land on which you are situated. I am situated on the unceded territory of the Anishinaabe-Algonquin Nation. Nous aimerions reconnaître que nous participons à cet événement virtuel d'un bout du Canada à l'autre et nous vous invitons à reconnaître le territoire sur lequel vous vous êtes situé. Le territoire sur lequel je me trouve est le territoire non cédé de la nation Algonquin Anishinaabe. The Honorable Justice Reginald, Justice Penty, and and Justice Pamel and Dr. Cameron are presiding. La Cour, présidée par Monsieur le juge Reginald, Monsieur le juge Penty, et Monsieur le juge Pamel et Dr. Cameron présidée. The judges may now invite the appellants to begin their submissions.
Counsel,
Good afternoon, Justices. I appear today alongside my co-counsel Salman Abbasi, and we represent the appellant, the Minister of Citizenship and Immigration. The case before you concerns the authority of the Refugee Protection Division as an independent and specialized tribunal to consider and weigh unsolicited and untested evidence in the course of a refugee proceeding. The RPD is a master of its own procedure and is entitled to obtain a full and fair understanding of the allegations made in a claim pursuant to the Immigration and Refugee Protection Act. The appellant acknowledges the vulnerable position of women and child refugee claimants and recognizes the importance of trauma-informed adjudication in these claims. However, the severity of the respondent's alleged experiences should not taint how the law and statute are construed and understood. The appellant will be making 3 submissions today. I will be presenting the appropriate standard of review for this court, as well as addressing the first submission, and my co-counsel will be presenting the second and third submission. First, the RPD has met its duty of procedural fairness in the adjudication of the claim, and they're entitled to consider and weigh the unsolicited evidence in the interests of procedural justice. Second, the RPD's credibility finding and subsequent refugee claim decision were reasonable and responsive to the evidentiary record. And third, the federal court's analysis of the RPD decision strays outside the bounds of reasonableness review. I'll begin by addressing the appropriate standard of review for this court on appeal, which can be found at paragraph 26 of our factum. We cite Huruglicka and Kanthasamy for the principle that a certified question of general importance to the refugee law system does not fall under any of the exceptions to the standard of reasonableness. This court must step into the shoes of the application judge to assess the refugee decision and certified question in accordance with the standard of reasonableness. In support of the appellant's first proposition, I'll be making 3 further submissions, which can be found in paragraphs 28 to 57 of our factum. First, the certified question should be answered in the affirmative, as the rules of evidence in a court of law differ from the evidentiary rules in refugee protection proceedings. Second, the exclusion of the unsolicited evidence would impede the truth-seeking function of the RPD and place the administration of IRPA into disrepute. And third, the onus was on the respondent and her competent counsel to apply to cross-examine Mr. Barbosa if they believed it would assist her claim. Her failure to do so cannot amount to a breach of procedural fairness. First, the certified question of the federal court asks whether unsolicited evidence, including affidavit evidence filed by the agent of persecution, should be admitted and considered by the RPD. This question should be answered in the affirmative, and the corresponding submissions can be found at paragraphs 38 to 47. Judicial proceedings are adversarial in nature, and they involve technical rules of evidence which operate in tandem with many exclusionary principles found under the Canada Evidence Act and in the case law. On the other hand, administrative proceedings are far more relaxed in their procedures and policies surrounding evidence disclosure to advance their inquisitorial function. Part of this content of procedural fairness includes the tribunal's ability to fashion its own coherent procedure, adhere to it, and render decisions based on IRPA and the relevant policies. The policy on the treatment of unsolicited information before the RPD sets out a preliminary threshold for the use of unsolicited evidence under Section 5. It states that evidence must derive from an identifiable informant with respect to an identifiable claim, and the informant must be available for testing where it's subsequently requested by the RPD. Where it meets this threshold, it means the information can be adequately tested. The RPD then has a meaningful advantage at the hearing to determine whether the evidence should be admitted and weighed.
Counsel, let me ask you, you mentioned adequate testing as being a requirement. Is adequate testing a precondition to the admission of unsolicited information?
Yes, so Section 5 of the policy essentially sets out the 3-part criteria.
Right.
Yes, sorry.
All right, so it is a precondition.
That's right, it is.
So in this case, was there adequate testing? And in what form did that take place?
The evidence needs to be adequately testable. So if it passes through the 3 criteria, it can be adequately tested. But the onus is not necessarily on the RPD to do that testing. It falls on the respondent and her counsel.
So let me ask you this. If in fact, they decide not to, for whatever strategic reasons they may have, you're saying that that information, that unsolicited information, can never be admitted?
No, the unsolicited information can be admitted if it meets the 3 criteria under the policy, under Section 5.
You're saying it has to be testable, not tested.
Right, testable.
Okay, fair enough. Okay.
Okay. May I continue with my
Yeah, please.
submission? Okay, thank you. The RPD is not bound by technical or legal rules of evidence and can base a decision on evidence they consider credible and trustworthy in the circumstances, pursuant to sections 170G and H of IRPA. When viewed alongside the unsolicited evidence policy, section 170 affords the RPD significant discretion to assess and weigh evidence and to make findings of fact. If the RPD finds that the evidence of an informant is more believable and trustworthy, they are entitled to admit and weigh it accordingly, as they have a meaningful advantage to consider all evidence at a hearing.
Counsel, would you agree that the policies and guidelines may be helpful but aren't binding? That it's the statute and the regulations that are binding?
While I would agree that the statute is binding, I would like to note that the policy is created pursuant to the statute and pursuant to section 170G, where the RPD is not bound by technical rules of evidence. They are able to fashion their own policies regarding how to actually admit and consider evidence.
And in doing so, are there any limits on how far they can go?
Well, the limit is informed by credibility. Where they can establish credibility, they are able to admit and weigh it, and any deficiencies in the evidence will go to its weight.
So in terms of testability, would it be your position that an unrepresented refugee claimant appearing with the assistance only of an interpreter in the face of evidence, unsolicited evidence from the agent of persecution, might lose their case because they didn't have the capacity to test it? Because you've just taken the position that the RPD has no onus, the onus is all on the applicant. Well, let's assume an unrepresented applicant doesn't speak English or French, relying completely on a translator, someone who suffered torture, sexual abuse, physical abuse. Your position is, the government's position is that the onus is on them to test that evidence.
Justice Penty, I would like to note that procedural fairness is eminently variable and context dependent. And that's noted by Baker, which is a Supreme Canada decision. And in that case, I'd like to just distinguish the self-represented litigant scenario that you've put forward with the facts of this case. This respondent had competent counsel who ought to have informed her of her right to cross-examine and her implicit waiver of that right.
Thank you.
Thank you. The minister cites Cambie Hotels at paragraph 41 for the principle that administrative tribunals are masters of their own procedure, and their duty to consider all relevant evidence is a matter of procedure, not substance. The respondent contends that the appropriate forum to test this evidence is in the family law proceedings, but we respectfully disagree. While the evidence is from family law and refugee protection proceedings, the current proceedings are before the RPD, a specialized tribunal with specialized evidentiary principles. The RPD's relaxed standards of evidence are there to fulfill its truth-seeking function and to encourage fair and impartial decision-making.
But counsel, how do you reconcile your position with guideline 4?
Justice Reginbald, I'd like to note that guideline 4 is it's a directive guideline. It's not binding. And here the RPD has meaningfully considered the guideline by appointing a designated representative for the minor claimants. Any further procedural accommodations that lie within section 4.2, for instance, of the guideline for vulnerable claimants would have had to have been sought by respondents' counsel.
But is it also incumbent on the RPD to ensure that that the refugee claimant that alleges domestic abuse be protected from her alleged assailant?
Yes, but we are submitting that has been met here. The RPD has meaningfully engaged with the guidelines, and we believe that the onus now shifts on the respondent and her counsel to fulfill any further procedural duties and rights.
Thank you.
So returning to my point about this evidence being subject to testing in family law proceeding, I'd like to note that This can't stand. The testing of evidence is properly situated in the refugee claim proceedings due to the glaring procedural and evidentiary differences between administrative and judicial proceedings. In the alternative, if this court agrees with the respondent that the evidence should be subject to the rules of law in family law proceedings, then the appellant cites JLZ and Refugee at paragraph 44 of our factum for the principle that untested evidence is permitted and often necessary in family law proceedings where the best interests of the child are engaged. I will quickly draw you to the facts of JLZ as it parallels quite closely with the respondent's assertions with respect to the untested evidence. In JLZ, a mother appealed a trial decision respecting parental alienation on the basis that untested evidence was used to arrive at the parenting arrangement decision, and that she did not have the ability to exercise her right to cross-examine, she did not have the opportunity to cross-examine. The Court of Appeal found that the decision to grant an adjournment to cross-examine is highly discretionary and requires significant appellate deference on review, especially when the trial judge has rendered their decision and afforded significant weight to that untested evidence. In the present case, the untested evidence should be admitted and considered if it is subject to the rules of evidence in family law, as it directly implicates the minor claimants and their best interests. Justices, with respect to the first submission, the minister argues that the certified question should be answered in the affirmative. The RPD is a master of its own procedure and has the authority to decide, pursuant to the unsolicited evidence policy and IRPA, on matters related to the admissibility and weight of evidence. To argue otherwise would ignore the stark evidentiary differences that exist between judicial and administrative proceedings and fetter the discretion of the RPD to make evidentiary decisions. Subject to any questions, I will be moving on to my second submission. That a coherent procedure regarding the admission and weighing of evidence is a fundamental pillar of procedural fairness. To exclude the unsolicited evidence in this case would undermine the truth-seeking function of the RPD and undermine their authority to construct and adhere to their own policies and procedures. The minister acknowledges the procedural right of applicants to present their case, to understand the case they have to meet, and an opportunity to respond. However, this right must be balanced against the principles of fairness and natural justice, which call for a coherent procedure. As I noted earlier, sections 170G and H of IRPA equips the RPD with the authority to create and follow the unsolicited evidence policy to satisfy its inquisitorial function. In OLA, the federal court recognized that IRPA allows tribunals such as the RPD to expeditiously resolve administrative matters without being constrained by the procedural formalities in judicial proceedings. The reference paper of the IRB on weighing evidence, cited in paragraph 35 of the factum, states that a disputed fact is considered sufficient if its cumulative weight warrants that a finding of fact exists. Now, the content of Mr. Barbosa's evidence directly relates to his character and conduct and contradicts the risk alleged by the respondent. The unsolicited evidence from parallel family law proceedings, the unsworn affidavit, and the transcript evidence in Mr. Barbosa's refugee proceeding led the tribunal to conclude that he was a good father to his children, as his unsolicited evidence passed the preliminary threshold under Section 5. It was reasonably found to be credible and trustworthy under Section 170H, and the RPD's finding of fact that he was a good father could not be challenged with the respondent's basis of claim narrative, corroborative evidence, or oral testimony.
Counsel, if I may, to be clear, are we talking now still about the admissibility, the threshold trustworthiness finding, or are you talking at the same time about the ultimate weight that this evidence was given in the hearing?
Since the RPD is a master of its own procedure, we are kind of considering both at the same time, is that they were raised simultaneously in the facts of the case as well.
Then counsel, if I may, in your excellent factum, I think you somewhat sidestepped the members' finding that Mr. Barbosa's evidence should be presumed to be credible. And I understand your argument was that this was not the primary basis for the adverse inference, but I'm curious if you think that this finding was defensible.
Sorry, could you clarify a little bit?
The member found that Mr. Barbosa's evidence was not only on its face superficially compelling, or that it met a standard. He found that it was presumed to be credible because it was sworn evidence.
Yes.
And I'm curious whether you would agree that that was a defensible finding.
I would agree. The RPD found that Mr. Barbosa's evidence in both the parallel family law proceedings and the family law and the refugee protection proceedings were subject to the Maldonado presumption of truthfulness. And on top of that, there was internal consistency, which, as Maldonado states, is a relevant factor to consider when the evidence is comparable and the narrative remains the same. And in this case, my co-counsel will touch on later in submissions, there were material omissions that resulted in the respondent's evidence being rebutting the presumption of truthfulness.
I understand that, counsel, but I'm on that question of Mr. Barbosa's evidence being presumed under Maldonado to be credible. The way I've always thought about this, and you're free to suggest that I should think about it differently, the presumption of credibility in a refugee hearing is essentially a presumption of innocence on that question of credibility. In a criminal trial, since by law the accused is presumed to be innocent, we wouldn't presume that the sworn testimony of adverse witnesses is credible, even though that evidence is sworn. In other words, it would be a serious error of law for a judge to presume that a complainant in an assault trial was credible, because this would undermine the accused's presumption of innocence. How is this different?
I would turn it back to the fact that the RPD is a master of its own procedure, and the current climate that we're in is distinguishable from judicial proceedings. Here, the identity of an informant is not relevant to the analysis of the probative value of the evidence. Credibility is determined based on a multitude of factors that the RPD may consider, such as the internal consistency and the presumption of truthfulness of an informant. If we were to exclude this evidence because someone is alleged of misconduct or a crime, it would in effect put the administration of IRPA into disrepute and fetter the discretion of the RPD.
Counsel, if I may, last point, just to be clear, I'm not talking about excluding it. I'm talking about presuming him to be credible based on the fact that his evidence is sworn.
Right. And the respondent was afforded the same presumption until it was rebutted. And that is, the RPD is entitled to do that because they're not bound by any technical or legal rules of evidence under Section 170G. Does that answer your question, Justice Cameron?
Thank you, counsel.
Thank you. Justices, with respect to the second submission, the minister argues that the exclusion of unsolicited evidence, which has been found credible pursuant to the unsolicited evidence policy and IRPA, would undermine the truth-seeking function of the RPD. I'll be moving on to my third and final submission, that the onus was on the respondent and her counsel to apply to cross-examine Mr. Barbosa if they believed that doing so would support her claim. A breach of procedural fairness cannot be argued where the respondent has implicitly waived that right to test the evidence. This submission can be found in paragraphs 47 to 57. As mentioned earlier, the RPD does not have an independent duty to compel all witnesses to appear for cross-examination. They do have a duty to process claims without undue delay. The RPD's procedural duty requires them to provide adequate notice of the case the claimant must meet and an adequate opportunity to respond, all of which has been satisfied here. In paragraph 50 of the factum, we cite Zaloshna for the general principle that there is no duty on the RPD to call a witness to testify if they have determined that the evidence is credible. Where a refugee claimant believes cross-examination will assist her claim, the onus is on them to apply for it under Rule 45 of the RPD rules. Similarly, if the respondent and her counsel believe that Mr. Barbosa's evidence would undermine her credibility or raise issues surrounding her evidence, they should have either compelled Mr. Barbosa for cross-examination, sought an adjournment to determine what alternative means of testing the evidence was available under the gender guidelines, or engaged in an alternate. Sorry, was there a question? No. Or engage in alternative measures to test the evidence, such as written interrogatories. The respondent did not apply to test this evidence in any capacity. She cannot raise the specter of procedural fairness after abandoning her right to test this evidence. I am cognizant of the time, Justices.
So, Counsel, let me just jump in and ask one question. Is it your position that, so we can all agree that this is a highly unusual circumstance? You're putting all of the onus on the refugee claimant and or their counsel to ensure a fair proceeding. Is there no obligation on the RPD to propose or suggest options or alternatives to raise exploration? Here they took all of his evidence. Did they ask at all for her evidence from the family law proceeding? I didn't see anything in the record to suggest. So that's just one example of the kinds of things that. Does the RPD have no obligation in terms of it's ultimately responsible for the fairness of its proceeding? So does it have no obligation to raise any of these or explore any of these options?
Thank you, Justice Penty. The respondent's sworn affidavit from the family law proceedings was actually also considered by the tribunal in determining her credibility as well. But to respond to your question regarding procedural fairness, it varies on the circumstances. Here we have a respondent with a competent counsel. There have been no submissions raised as to the counsel's competency. And the RPD does place an onus based off of the guidelines, the statute, for the respondent and her counsel to test this evidence if they believe it's conducive to a good claim. And that's not been satisfied here. In this case, the respondent ought to have been informed by her counsel that the waiver of her right to test this evidence may result in Mr. Barbosa's evidence being given significant weight in these proceedings.
Thank you.
Thank you. So Justices, I will just defer to the rest of my written submissions on the section 166C point, but with respect to the third and final submission, the minister submits that the respondent waived her procedural right to test the evidence when she failed to apply for cross-examination or alternative means of testing the evidence. In summary, the RPD is afforded considerable discretion to admit and weigh unsolicited evidence pursuant to the policies and procedures that they have created and that the statute has meaningfully informed. In the respondent's case, the RPD satisfied its duty of procedural fairness by fashioning a coherent procedure and adhering to it. The respondent and her counsel cannot raise the specter of procedural fairness after having abandoned this right to test the evidence. Subject to any questions, I will now turn it over to my co-counsel to present our second and third submissions. Thank you, Justices.
I will be presenting two submissions. The first being that the RPD's credibility decision was both reasonable and responsive to the evidentiary record. The second submission will be on how the application judge's analysis of the RPD's decision strayed outside the bounds of the reasonableness review. For my first submission, I'll show that the RPD's credibility decision was both reasonable and responsive to the evidentiary record put before the RPD, and that argument will firstly touch on the material omissions found on paragraph 58 to 69 of the appellant's factum. Primarily, the RPD's decision to render a negative credibility assessment was reasonable. This is due to the numerous omissions found between the respondent's amended basis of claim narrative, the respondent's affidavit filed in the parallel family law proceedings, and the oral testimony at the refugee claim, all of which combined undermined her credibility. Specifically, the respondent in her family law proceeding and oral testimony made detailed allegations of child abuse. However, that level of detail was glaringly missing in the previous oral testimony during her refugee claim. This is problematic. The federal court is clear in Sari v. Canada that the accumulation of these omissions regarding crucial elements of a refugee claim all go towards supporting a negative conclusion about an applicant's credibility. The details that were left out were extremely relevant to the respondent's refugee claim and the assessment of risk under Section 96 of IRPA. The respondent omitted not only significant, but recent events of alleged child abuse, despite modifying her basis of claim at the outset of the hearing to include allegations of domestic violence. From Bouchard v. Canada, we learned that the RPD is empowered to make credibility determinations based on the omissions in a basis of claim if the omissions were important aspects of a claim. These numerous omissions are directly material to the respondent's risk of domestic abuse and are therefore very important to the proceedings themselves. Finally, in Oculus v. Canada, the federal court determined that the claimant's omissions in her evidence can undermine their entire oral testimony. There is a long line of jurisprudence supporting that the RPD is not only allowed to, but must take note of these omissions in the respondent's evidence. The RPD considered both the unsolicited and transcript evidence provided by Mr. Barbosa in conjunction with the respondent's material omissions to make general inferences of credibility.
Counsel, I have an issue with the affidavit evidence in the family law trial. The issue there is that I'm questioning the reliability of that affidavit, because I'm sorry, I'm talking about the affidavit. The transcript of the father's refugee claim that was used by the RPD, and that particular transcript and that particular evidence did not relate to domestic violence, but more for his claim for protection. So why is that relevant, and why is that transcript so relevant and so reliable in determining whether or not the mother is also at risk because of domestic violence? That's where I'm not sure on the reasonableness of that assessment.
Of course, primarily the minister sought to disclose that piece of evidence to the RPD. It is a piece of evidence that is sworn and consistent with the family law proceedings, but ultimately it's not the role of this court or the federal court to assess and reweigh this sort of evidence. The RPD board member functions as a very discretionary role as intended by Parliament. That role to assess whether the evidence was needed and the weight of that evidence rests solely with the RPD board member himself.
Okay,
Does that answer your question?
Counsel,
Yeah.
if I may just jump in on Justice Reginbald's question there, then again, we have a finding from the member that he is presuming that this evidence is credible. What should we make of that in the context of the assessment of the evidence? In other words, you're giving us other reasons why that evidence might have been found to be not credible, but is any of that relevant if he's already presumed that this evidence is credible?
Of course, the presumption of innocence rests because again, citing Maldonado, the presumption of truthfulness attached itself to the evidence because it was not contradictory in nature, and because the material omissions from the respondent's testimony undermined itself. Therefore, Mr. Barbosa's evidence formed a more believable version of events. But again, this is in line with the RPD mandate. They're allowed to assess and the credibility and the weight of the evidence before it as Parliament intended.
So counsel, just on that point, is there any requirement in doing that to acknowledge that he had a vested interest? He was not an innocent bystander, whether the allegations against him are true or not. He had a vested interest in the outcome of this proceeding. There's an allegation that he should be presumed to be biased. So you've got Maldonado on the one side, but Maldonado in context. Is there any obligation on the RPD to explain how, in light of his interests, that evidence ought to be considered, or at least to discuss that?
Of course, the identity of the claimant and of the person that provides the evidence is not a problem for the RPD itself. That is a problem for the respondent who had a chance to cross-examine the evidence submitted in the proceeding to cross-examine. The RPD is again under no obligation to do this.
So absent that, your position as Maldonado is irrebuttable, just on the face of it. Someone who comes before the board with 7 convictions for recent perjury on all sorts of things in criminal context directly relevant to their claim, but then cheerfully swears an affidavit for the is it your position then that that's presumed to be true?
It's our position that the RPD applied both the presumption of truthfulness here. They looked at the internal consistencies and the lack and the deficiency of the corroborating evidence of the respondent, as well as Parliament's power and discretion to make findings of fact to ultimately come to the conclusion to declare Mr. Barbosa's evidence as more believable than the respondent's.
Thank you.
I will now touch on the gender guidelines and the suggested use of them found in paragraph 70 of the appellant's factum, and how this use by the application judge is problematic. Firstly, it's established through Deremy v. Canada that the gender guidelines are not a cure-all for a lack of credibility found by the RPD. In Newton v. Canada, the federal court stated that the guidelines cannot be treated as corroborating any evidence of gender-based persecution so that the giving of the evidence becomes proof of its truth. The RPD was very attentive to the respondent's vulnerable position as a female alleging gender-based violence, and they exercised correctly the principles of trauma-informed adjudication when assessing the respondent's claim, as witnessed in paragraph 70 of the appellant's factum. Had the respondent felt any prejudice or trauma appearing before Mr. Barbosa, there were multiple avenues open to her throughout the proceeding that she chose not to utilize. Requesting an adjournment, using written questions, or presenting alternative reports are all methods which satisfy the purpose of cross-examination. Instead, the respondent is relying on a severe misapplication of the gender guidelines to exclude both probative and credible evidence, which she cannot do, citing the rulings of both Okpanache and Ola v. Canada. It's of the utmost importance to recognize that the purpose of these gender guidelines is to ensure that proceedings remain fair in the face of any and all gender concerns. These, of course, not only apply in this context, but must protect the respondent as well. However, the application judge and the respondent cannot manipulate the guidelines in such a manner to remedy her lack of credibility findings and to oppose the cross-examination of a witness. Utilizing the gender guidelines in this manner to discard and discredit evidence before the RPD frustrates the very core purpose of the guidelines themselves, giving ways to proceedings which are inherently unfair and unreasonable. This is also a severe imposition on the function of the RPD's truth-seeking legislative mandate. Subject to any questions, I will be moving on to my second submission.
In that regard, Ken, just a very quick question. The minister intervened and brought forward this evidence. In doing that, did the minister have any obligation to bring forward suggestions, proposals, ideas? What would your submission be if I put to you that in acting that way, the minister is very much acting like a Crown Counsel would in a criminal proceeding, where they're not to have a vested interest in the outcome, they're to assist the decision maker achieving truth. So does the minister then just get to drop that and remain silent, or does the minister, as the chief law officer of the Crown, have an obligation here?
What the minister's obligation may look like in an RPD proceeding is entirely subject to the fact that the RPD board member himself is the master of its own proceeding. This is very clear in IRPA, especially in section 170. I will touch on further submissions where the application of the rule 21.5 and the safeguard found in that, and how that application was done incorrectly by the application judge, which may answer that question more fully. But again, the RPD is a master of its own court, and the role of the minister in that is dependent entirely upon what the RPD presumes it wants it to be.
Thank you.
I will speak about the unequal scrutiny of evidence argument by the application judge. Firstly, the application judge started off citing R.V. Shanmani, which is a criminal law case. Criminal case law is very difficult to apply in an administrative context due to the stark difference between the burden of proofs in civil and criminal jurisdictions. However, even in Shanmani, the uneven scrutiny argument was denied as a grounds of appeal due to the court already finding great difficulty in proving credibility findings when they were already rendered in a previous trial decision from a lower court, very similar to this context. Secondly, the RPD is fully within its authority to determine when it is necessary to test evidence via cross-examination. I ask your honors to refer to the IRB policy document on weighing evidence, chapter 6.6, found on paragraph 80 of the appellant's factum. It clearly states that when there is a conflict in the record, the IRB is entitled to choose within the range of reasonableness the evidence it prefers, and it is not the role of the reviewing court to reweigh that evidence. Simply put, the RPD found that the evidence submitted by Mr. Barbosa was credible. They were under no obligation to further test the evidence. The respondent's own material omissions in her evidence led to a rebuttal of the presumption of truthfulness. Therefore, it's reasonable for the RPD to cross-examine her. To do otherwise would...
Counsel, reasonableness review also requires the court to look at contradicting evidence. And to the extent that the tribunal below did not discuss the contradicting evidence and did not weigh it and dismiss it outright, then that's a signal that perhaps the tribunal below did not consider a relevant ground. And that is open then for the court to determine that the decision maker was unreasonable on that ground. And so here what we have is we have some transcript and we have to have some evidence in other contexts that are to some extent opinion evidence and also biased evidence. And that does not seem to have been considered at all by the tribunal below. In fact, it was presumed to be credible. And so what's your position on that?
Of course, firstly, in regards to the opinion evidence and the hearsay evidence that was submitted, again, citing IRPA policy 170, section G, the IRB is not bound by any legal or technical rules of evidence. Therefore, whatever the RPD board member believes in his discretionary view to be credible, they are allowed to analyze that evidence as they deem fit. Your second point about how, yes. Okay.
Continue, Alistair.
Of course. Your second point about how the RPD board member dismissed the corroborating evidence of Ms. Reyes. There was no dismissal of this because in the RPD board members' reasons, they were alive and responsive to the neighbors' reports that they received. They were alive and responsive to the psychiatrist report. And they're mentioned in the reasons, citing Vavilov, the reasons do not need to be a line-by-line analysis, but the parliament and the integrity of that statute allows the RPD board member to provide reasons that, as long as they are reasonable within the context, as long as the whole and the entirety of the reasons are reasonable in the context and are void of these factual and legal and are void of any glaring errors, they are reasonable. And that is what has been done here.
But my question is slightly different. The issue here is that the tribunal below failed to appreciate that the evidence that was provided by the father was on its own biased. And not only that, but it was part of the family law proceedings where they were fighting for custody of the children. And so, in my view, the problem in your case is that the tribunal below did not take that head on, weigh it, and then after it has been done so and considered the contradicting evidence, then it can decide whatever it prefers. But by the fact that it did not even address that issue, it leaves me with the perspective that it may have failed to having conducted a proper analysis. And that's why I'm looking for your guidance.
Of course, again, it is not the RPD's onus to explore potential areas of bias, because that onus rests entirely with the respondent, who was given time, who was given our opportunity, and was again guided by competent counsel, but chose not to pursue these allegations. The respondent cannot ask the RPD to engage in conjecture about Mr. Barbosa's intentions when they themselves abandoned the right to test that evidence and seek out this bias.
So your position is that the RPD, seeing the elephant in the room, does not have to consider it because it's not raised by the other side.
The RPD, as a master of its own court, is allowed to render assessments on credibility and weight. And in this case, they found the evidence credible because of the presumption of truthfulness and the material omissions and large gaps found in the respondent's evidence.
Okay, thank you.
You've covered the question I was going to ask you, counsel.
Okay. I will now speak to the application of Rule 21.5 and that is referenced in paragraph 81 of the appellant's factum. The application judge made an error in law with respect to the interpretation of this rule. The safeguard found in 21.5 only applies to the RPD seeking to introduce the evidence themselves. However, in this context, it was not the RPD, but the minister which disclosed evidence, making this unapplicable. Referencing Rule 21.6, any personal or other information which originated before the respondent severed her claim is not subject to the safeguard anyway. The respondent cannot reasonably ask the RPD to exclude the very information she included in their joint claim. Lastly, I'll touch on the reasons being not read in light of the evidentiary record. The application judge states that the RPD board members' reasons failed to provide clear and unmistakable reasons, but this runs contrary to the ruling in Vavilov, where it's determined that where reasons are required, they must be based on internally coherent reasoning and must be justified in relation to the legal and factual constraints that bear on the decision.
Counsel, sorry to interrupt, would you agree with me that one of the things that's also said in Vavilov is that the nature and strength of the reasoning increases proportionate to the vulnerability or the impact on the individual? So a licensing decision, some bylaw, something, okay, dog catching, okay. Refugee claim by a woman who says she suffered and her children have suffered extreme domestic violence. Does that not sort of ratchet up the RPD's obligation to explain in detail, going back to Justice Regenball's question, why it's choosing to accept sworn evidence from a person with a vested outcome delivered in a different context over the sworn testimony of the claimant who appeared before it.
I agree with your analysis and your hypothetical scenario put forward. I would simply refute it with the fact that Vavilov states that administrative justice looks very, very different than judicial justice. The reasons provided by the RPD were illuminative and grappled with key issues when analyzed in their full context. Because of this, that is why they are reasonable. Does that answer your question?
Yeah, sorry, I'm trying to unmute myself. Thank you.
Thank you. I believe I have ran out of time, so I will allow for the rest of my written submissions to cover the reasons argument found on paragraph 86 of the appellant's factum. I will just conclude with the order sought, and the appellant seeks that we would like the appeal to be allowed, the certified question to be answered in the affirmative, and a reinstatement of the board members' decisions. Subject to any questions, that concludes the appellant submissions.
Thank you. I think we've asked you enough questions. Counsel?
Yes, I will begin if the justices are ready for my submissions.
Yes, please.
Thank you. Honorable Justices, Counsel for the Appellants, my name is Zara Shirur, and I am with my co-counsel, Levon Meridian. We represent the respondent, Isabella Barbosa Reyes, in the case of Isabella Barbosa Reyes and the Minister of Citizenship and Immigration. I will begin with an overview of our submissions and also about the issues pertaining to the unsolicited information. My co-counsel will speak afterwards regarding the transcript evidence. He will conclude with the remedies we are seeking. The respondents ask the court to answer the certified question in the negative. That is, the unsolicited evidence filed by the agent of persecution should not be admitted and considered, especially in light of the fact that it was untested, and because allowing the admission of this evidence would undermine the integrity of Canada's refugee determination system and its mandate to protect persons in need of protection. This case is really about the protection of non-citizens from the powerful engines of the administrative state and with ensuring integrity, fairness, and trust in the refugee determination process. Refugee claimants should be able to have certainty in the way in which RPD members are assessing their claims, particularly regarding credibility assessments. At issue here are the principles of natural justice and reasonableness, but putting policy to the side, this case is really about protecting vulnerable women like Ms. Barbosa Reyes, who are subject to domestic abuse and intimate partner violence and now trying to avail themselves of protection from Canada. We must be seen as a country which protects these vulnerable women in a way that does not participate in their re-traumatization. It is for this reason that we submit that it was unreasonable for the RPD member to admit the transcript evidence and unsolicited information to the respondent's RPD hearing, which was derived from the respondent's agent of persecution, her abusive ex-husband, Mr. Barbosa Reyes. We also submit that it was unreasonable for the member to place substantial weight on the transcript evidence and unsolicited information, which was provided by the agent of persecution.
Counsel, let me ask you, are you suggesting that the mere fact that it came from the agent of persecution is grounds alone to not admit the evidence?
We're suggesting the fact that because it came from the agent of persecution, the evidence should be scrutinized and treated with suspicion. However, the ultimate issue here is the fact that the information was not tested, and I apologize, and was virtually untestable due to issues regarding cross-examination and re-traumatization of the respondent.
But counsel, the evidence was not tested because your client decided not to test it. There are some ways to test that evidence that can also, reduce any prejudice that your client would have suffered, yet would have allowed the RPD to find the truth. And that's what the bottom line of what the RPD is after, correct?
So it is true that there are procedural mechanisms that could be used by the RPD member in order to ensure, in order to prevent re-traumatization. And my co-counsel will speak further on this point. However, I do wish to simply say that these mechanisms themselves were, we submit that the onus was on the RPD member as per the gender guidelines to provide and explain these procedural differences. As my friends have stated, you know, RPD members are masters of their own proceedings. And so the onus is on them to explain to the claimant that they should, these kind of different protections that could be used and implemented in the refugee hearing. If there are no further questions, I will proceed with my submissions. And I will begin with the third issue, which can be found in the respondent's factum at paragraph 39. And I will allow the court a few moments to pull up that paragraph.
Thank you. Go ahead.
Thank you. We submit that the RPD member's decision to admit the unsolicited information was unreasonable. Firstly, this is because the third criterion regarding the treatment of unsolicited information was not fulfilled. It is also because the prejudicial weight of the information outweighs its probative value. At paragraph 40 of the respondent's factum, we outline the policy regarding the treatment of unsolicited information as potential evidence. We do concede that the first two criteria are fulfilled. However, the member did not fulfill the third criterion. In the respondent's case, the informant was not requested as a witness by the RPD. And yes, this is a discretionary power. The RPD member, however, the RPD member must still act in accordance with relevant case law and jurisprudence pertaining to this policy, and as per Vavilov states. And in order to admit the information, it should have been tested through a verification process.
Counsel, your friends are telling us, and they spent a considerable amount of time telling us or arguing that it is not the RPD's position or responsibility to test. It may be under certain circumstances, but not in the circumstances that face us today. So I asked to you the same question that I asked your friends. Whose responsibility is it to adequately test the in this particular case, the unsolicited information before it is admitted?
We submit that the responsibility to test the information is the RPD members.
And you say that because why?
And we say that because cross-examination was the form of verification that should have occurred, and that is a procedural right that should have been afforded to the respondent.
And was it not afforded?
Cross-examination? No, it was not afforded.
But
Did you ask for it?
Yeah, well, that's the follow-up question.
So as I stated before, the respondent did not ask for cross-examination due to issues of traumatization and issues facing her abuser in a refugee claim context. And this would additionally have issues with her recounting her claim and various other things pertaining to that. And I will also assert the fact that Rule 45 is discretionary. So there is no guarantee that even if the respondent had asked for cross-examination, that she would have received it, yeah. Especially because the RPD member had said that he did not think that cross-examination was necessary.
Well, he said that in the decision, but let me get this straight. How would that, and I take all the concerns that you raised as valid concerns. How would any of that changed had the RPD requested the cross-examination, requested for the father to appear to be cross-examined? How would any of those issues been alleviated?
And this is the problem, Justice Kamel. You've hit it right, the nail on its head, exactly. So our argument is that
that's the first time in history I've done that. So.
Well, our argument is that the unsolicited information either should not have been admitted or it should have been granted little weight because cross-examination was effectively impossible to do due to these gender-sensitive issues. And so this relates to our secondary argument regarding the credibility assessment on this point, in that the respondent was in a lose-lose situation. She wanted to cross-examine the information, but due to her PTSD and her depression, was unable to do so. And which is why we submit that because this verification could not have occurred, there was difficulties in this verification occurring, then either it should not have been admitted or it should have been granted less weight by the RPD member.
But counsel, accepting that that reality is true for the applicant, are you alleging incompetence of counsel? Because it wouldn't have been her doing it. In terms of cross-examining and testing, she could have provided information to her counsel to assist in the cross, but it's not her confronting him. It is as directly as I think you've just put it, it's her lawyer.
Of course, I apologize for my voice. Of course, it would be her lawyer who would be conducting the cross-examination. However, there are additional reasons and issues as pertaining to her giving information to her counsel during the cross-examination. Some of these procedural alterations to the hearing occur having the respondent leave the room, for example. And we also submit that that would be unfair because, as you stated, Justice Penty, how would she have been able to give comments to her counsel if she was not in the room? This increases the level of difficulty for her. And we think that the RPD member should have, in his analysis and his reasons and decisions, in order to be responsive to the gender guidelines, as my friends have stated, he should have contended with these issues.
There are some safeguards available under guideline 4, for example. She could have been in a different room with her counsel and cross-examination be conducted on Zoom, for example. And that at least would have allowed your client to cross-examine the evidence and the RPD to have the entire evidence.
Yes, that is correct. There are alterations, but I will draw you back to my previous statement in which I said that the onus was on the RPD member in order to bring forth these alterations that could occur at the hearing, since it is the member themselves who must adhere to the guidelines and consider them in how they conduct their hearings.
But is it not also incumbent on the claimant and her counsel to raise these issues with the RPD so that the RPD is probably informed of the issues and then can rule?
Yes, that is true. And the respondent and her counsel did raise these issues. And they stated, for example, that the information was biased and that the agent of persecution had a motivation to be untruthful. And my co-counsel will elaborate on the gender guidelines further and how the RPD member didn't engage with them, manifestly engage with the gender guidelines. But there are instances where these arguments are mentioned in the RPD decisions and reasons and then not contended with afterwards. If the court has no more questions on this point, I will continue with my submissions.
Please.
And I would like to specifically, before I move on to credibility, discuss briefly probative value versus prejudicial effect. And we do submit that while the policy for the treatment of unsolicited information is important, there are other governing law that apply to the admission of evidence, some of which is, as we know, case law, and probative value versus prejudicial effect, which the RPD member must consider in the admission of evidence. So if the court would look to the respondent's fact at paragraph 41 and 42, the case then Balsingham in Canada outlines the legal limits for the admission of evidence, which are relevance and fairness. And fairness in the admission of evidence relates to probative value versus the prejudicial effect of the evidence. And probative value is described as the believability of the evidence and its informativeness. As I stated before, there were issues regarding the testing of the unsolicited information, and this makes it less believable, and therefore it subsequently has a lower probative value. Additionally, and this goes to the prejudicial effect of the information, the agent of persecution can only provide self-serving evidence, and he has, as I stated before, strong bias and motivation to be untruthful. And the RPD member does not address the fact that the unsolicited information had a potential to be self-serving in their reasons. And it is for that reason that the respondent submits that this highly prejudicial information outweighs the probative value of the unsolicited information, and it should not have been admitted.
Is it a question, counsel? I understand your argument on probative value. with respect to the prejudicial effect, is it a question of prejudicial effect or is it a question of credibility? The fact that he's the agent of persecution, I understand what you're saying, that he's got self-interest and he's got an interest to lie. That's, in essence, that's what you were saying. But does that go to the prejudicial effect of the evidence, or does that go to its credibility?
Justice Pamel, it goes to both, actually.
I'm trying to understand the link with the prejudicial effect. You're linking the prejudicial effect to your client directly, to how it's going to affect her, I
Yes.
take it. And is that the proper use of the concept of prejudicial effect in this context?
So if I were to clarify, prejudicial effect is that which prejudices the hearing as a whole, and as well as the prejudice that the particular claimant faces. So it's kind of a two-pronged idea. Allow me a moment of indulgence to sort of think through your question again. So your first question was, how does this relate to credibility? Does this relate to credibility?
More a question of credibility. I mean, he can say what he wants, but clearly if the RPD member says, look, the person was self-serving evidence, it may be probative, but it's I certainly give it very little credibility. But anyways, it was really the link with the prejudicial effect that I couldn't really understand where you were going with that. But I understand now. I understand a little bit better as to why you were saying it was prejudicial, and in what way it was prejudicial. All right.
Okay.
Thank you
so much. Justice Cameron, I believe you had a question as well.
Yes, just building off Justice Pennell's question, and I don't know, this may segue more into what your colleague will be speaking about, but on that question of prejudicial effect as you're framing it, I think what I come to is that I have no doubt that having to engage with her alleged abuser would cause significant hardship to the respondent. But as I read it, what I keep coming back to is that neither Section 170 nor Rule 21 prevents the board from admitting evidence that would cause significant hardship to a claimant. They rather make clear that this evidence may be admitted if it's credible and trustworthy, and in the case of the transcript, as long as it doesn't cause an injustice. And I read the member's admissibility finding against the backdrop of a situation where there are competing significant hardships hanging in the balance, right? With this family law case going on, if the respondent's claim had proceeded without Mr. Barbosa's evidence, and if he'd been found to be the agent of persecution, this, could have lost him his kids. Right? So I guess what I'm wondering is, the members looking at this situation decides that under these unusual circumstances, giving him a voice in this proceeding that could have a devastating impact on him would not be unjust, and that the evidence meets the low threshold for trustworthiness at the admissibility stage, so threshold trustworthiness, since the respondent has the ability to cross-examine him, which she chose not to do. I guess, on the question of admissibility, on a deferential standard, why should we interfere with that finding?
Thank you for your question, Justice Cameron. And what I will say about this point is that this is our first argument, and we have an alternative argument wherein if the court finds that the admittance of the information was valid, then that's where we move to the substantial weight portion of our argument. Additionally, I do want to mention something about the deference point, which I heard my friends stress very much, and I wanted to contend with this point as well. And what the respondent has to say about this is that it is true that the RPD member is entitled to deference in terms of their ability to admit evidence and their ability to assess credibility and various things like that. However, I want to draw the court's attention back to the fact that this information provided by the agent of persecution is documentary. And the court is also in a deferential position and has the ability to assess credibility and determine the valid admittance of evidence. This is not a function that is unique to the RPD in this way. And perhaps the situation would be different if the agent of persecution had been cross-examined by the member. And this would put more weight on my friend's argument about deference, but he was not. This is documentary evidence. And as I stated, when discussing documentary evidence, all triers of fact, including judges and justices, can make credibility and admittance assessments, and the respondents are not convinced that the member was entitled complete deference in this aspect.
But counsel, that there is case law that even if it's documentary evidence, that the trier of facts gets to determine the facts and is out deference on that, and a court of appeal is not to make its own weighing and determine those facts anew or de novo.
Yes, that is correct as well. However, this is just the respondent's pushback at this deference argument. The court is not being asked to reweigh the evidence, but instead to see that the way in which the RPD member conducted his reasonableness analysis was unreasonable because it was not justified in facts and law, intelligible, and that he relied on the agent of persecution's documentary evidence over the respondent's viva voce evidence in a way that was not intelligible, transparent, and justified in facts and law. If there are no more questions on this point, I will move to our next submissions regarding credibility. And this begins at paragraph 48 of the respondent's factum. We submit that it was unreasonable for the RPD member to consider the unsolicited information more credible than the respondent's evidence. This is because it is from the agent of persecution. The family law case is still ongoing. It is primarily self-serving and self-interested, and the Bach inconsistencies were not relevant to material issue. In the interest of time, I will be jumping in my submissions to specifically talk about the Bach inconsistencies, since it was a point that my friends had brought up, and it is also a point that I wish to contend with. If the court would be willing to go to paragraph 63 of the respondent's factum, I would like to assert that, unlike what my friends have stated, the respondent's Bach inconsistencies do not make her uncredible. In fact, my friends have cited the case of Sari in Canada, and I'll refer you to actually their factum at paragraph 64, where the federal court stated that an accumulation of contradictions, inconsistencies, and omissions regarding crucial elements of a refugee claim can support a negative conclusion about an applicant's credibility. And I would like to bring the court's attention to the operative word of accumulation. The respondent only had one omission, and this hardly amounts to an accumulation of contradictions and inconsistencies and omissions that warrants a lack of credibility finding. And as my friends have also asserted, the RPD has more relaxed rules of evidence than the court. So a claimant may actually omit details from a Bach, which they presume they will be able to elaborate on during the hearing itself. And if we now go back to the paragraph that I first referred you to of 63, this is where we outline the Pasai case, which is the test for a Bach omission, wherein the omission must be material to the issue of credibility. The respondent did include all material facts in her Bach, and this omission regarding the abuse faced by the children is not sufficiently material or significant to warrant a finding of a lack of credibility. And for the significance point, I will refer to the Sheikh case at paragraph 65 of the respondent's factum, which states that inconsistencies must be real, rationally connected, and significant to the claimant's credibility. And we submit that the omission was not significant and rationally connected. We can't forget the context here. The respondent is a traumatized mother who didn't want to write down the details of her children's abuse at the hands of their father. And additionally, in the case of Mojika Romo, the court stated that the RPD member should consider any justification that might explain the discrepancy. And the respondent gave reasons as to why she was vague in her Bach, and that she believed that the designated representative would file a narrative with the allegations for her children, and that she would be able to provide additional detail as to the abuse of her children at the hearing. The member should have taken this explanation into account in their credibility analysis. Instead, they simply deemed this explanation unreasonable without giving any reasons regarding this assessment of reasonableness. And instead, they seem to have engaged in a microscopic analysis of her claim, which was, first of all, not gender sensitive and not responsive to the issues that were alive in her case. the RPD member also didn't
Is
outline.
that what the trial judge found?
Sorry?
Is that are you speaking about the finding how the RPD should have dealt with it, or the findings of the trial judge?
I'm speaking about how the RPD member should have dealt with it.
Okay. All right. Okay.
Yes, and as I stated, and as Justice Cameron has pointed out multiple times, the RPD members seem to have presumed that the agent of persecution's evidence was credible. And then in order to determine that her claim and her sworn testimony was uncredible, they point to this one omission that is not materially relevant and frankly not significant at all. If there are no questions from the court on this point.
So I assume essentially you're relying on the Beltran line of case law in Lawani and Akbar that essentially the RPD was microscopic and overzealous in its determination of these discrepancies.
So what we are relying on is actually the line of reasoning regarding material relevancy and specifically the Sheikh case, which contends with the point that inconsistencies and omissions must be significant to the claimant's credibility analysis. However, Justice, you are right. We are aware of those cases and about how the RPD members should not be microscopic in their analysis, but we do not have that in our factum, so I cannot speak to them today. In my remaining time, I would like to move to conclude and essentially say that the RPD member erred in its credibility analysis and in its decision to admit the unsolicited information by not considering all relevant factors. And now my co-counsel, Mr. Mouradian, will proceed with a discussion regarding the transcript evidence. Thank you.
Counsel.
Thank you. Good afternoon, justices and friends. As my counsel mentioned, I will be speaking about the transcript evidence. My first submission is that the RPD was unreasonable in admitting the transcript evidence filed by the agent of persecution. Justices, I would like to start by acknowledging the fact that in practice, the RPD can admit evidence liberally, and they are not bound by legal rules of evidence. But justices, I would like to submit that this practice is not absolute. There are instances when admitting the evidence is not appropriate, and one instance is where the prejudicial effect outweighs its probative value. It is important to consider this in tandem with RPD Rule 21.5, which state that the RPD must not disclose personal or other information unless it is satisfied that there is no serious possibility that disclosure would endanger the life, liberty, or security of any person or cause injustice. The RPD member asserted that there is no proof or evidence that admitting this transcript evidence would cause injustice or endanger lives. But we submit that he did not fully consider the effects of this evidence. So the question then becomes, why was it that this admission endangered the security of the respondent? For this, we have to look at the chairperson gender guidelines. The guidelines recognize that female claimants may face specific problems when demonstrating that their claims are credible, and therefore the guidelines require the decision maker to consider the vulnerability of female refugee claimants. Justices, with this transcript being admitted, the respondent will face serious challenges and problems in continuing with her claim. As Justice Okoro explained in the federal court, the participation of the agent of persecution in the process could carry negative psychological impacts for the claimant and compromise her ability to present her case. In other words,
so counsel, if I can,
yeah.
so I go back to the question I asked your colleague. So what you're saying is that the fact that this evidence comes from the agent of persecution is in and of itself a bar to its introduction in this context.
Justice Pamel, it is not that every time an agent of persecution brings in evidence, it should not be admissible. But we have to look at the context. In this situation, with the guidelines in mind, with the transcript being only 7 minutes and 33 seconds, and various other issues that I will discuss later, combining that with the chairperson guidelines, we submit that in this particular situation, the admission was unreasonable. Thank you. So in the RPD member's opinion, the probative value of the transcript was outweighed by the prejudicial effect of the participation of her abuser. This assertion by the RPD member, we submit that it's unreasonable, as the guidelines indicate the severe prejudicial effects of admitting this evidence. Regarding my second submission, which is that the RPD member was unreasonable in giving the transcript substantial weight, we argue this for a couple of reasons. The first is that it was unreasonable to accord too much weight to the transcript because the RPD member failed.
I think you may
Counsel,
have
you just froze for me. Is he frozen for everyone?
frozen for me as well.
And now off my screen.
No, I still see him, but he's frozen.
Counsel, can you hear us?
Sorry to interject. I believe he's lost connection and will be reconnecting soon. I
Okay,
apologize.
thank you.
Okay.
It's in these moments that the tension builds.
Does anybody have a good joke?
At the end of this, we could ask all counsel what it's like to go through cross-examination by Zoom, but we'll come back to that.
Nice office, Peter. I'll have to visit you.
It's all my ships on the 12th floor. Yeah,
Yeah. Nice.
thank you.
My sincerest apologies
No.
to all those who are involved. I
Don't
faced some
worry.
technical issues.
Quite all right, please carry on.
Yeah, it's part of our
Thank you.
reality every day. Don't worry.
Counsel.
Yeah, thank you. So as I was mentioning, the RPD has set decisions aside if those decisions did not exhibit sensitivity that is required by the guidelines. In a case called Zamaseka and Canada, the RPD in that case similarly stated that they had the guidelines in mind when they made the decision, just as the RPD member did in this situation. But the federal court asserted just because the RPD member states that they had the guideline in mind, that is not enough for them to explain how actually they applied it. But there is another important case called Res Movis in Canada, and the facts are really similar to this case. In that case, a claimant made a claim for refugee protection and alleged that she was a victim of gang rape. The federal court asserted that by relying on the testimony of her husband to reject her refugee claim, violated one of the principles of the chairperson guidelines, which states that women refugee claimants face special problems in demonstrating that their claims are credible. So in the respondent's case, the RPD member claimed that he had the guidelines in mind, but he failed to consider and explain how this important principle from the Res Movis case was applied when he relied on the husband's testimony to reject her claim. Even though in Vavilov, the Supreme Court stated that the reasonableness standard is a deferential one, which of course we agree with, there still needs to be a robust form of review. So therefore, following Vavilov and the case law that I just cited, it was unreasonable to put so much weight on this transcript without explaining how the guidelines were applied. Another reason why we submit that the weight that was given was unreasonable for the transcript is because of the absence of justification, intelligible and transparent reasons as to why the testimony in the transcript was preferred over the viva voce testimony of the respondent. Viva voce evidence is usually given more weight than evidence that is not tested properly, especially when decisions are based on credibility, since the tribunal must give reasons for its assessment. Justices, what is really concerning in this case is that the RPD member's choice to give the transcript more weight, given its short length. This is because the majority of the testimony was about the fear from the CV gang and not regarding the applicant's claim of domestic abuse. In order to get to the truth, which is the RPD's mission in every case, the 7 minutes and 33 seconds that were allocated to question the abusive ex-husband about the respondent claim is simply not enough to test that he had the motivation to be untruthful. Although determinations of credibility are within the RPD's mandate, meaning that they have deference because of their position to observe the demeanor of a witness, nonetheless, it is very difficult to comprehend how the tribunal, in only 7 minutes and 33 seconds, was able to observe Mr. Barbosa's demeanor and make credibility findings in this short amount of time. Furthermore, honorable justices,
Counsel,
the RPD, yes,
Counsel,
yes,
may I?
Justice Cameron.
Am
Yes.
I understanding then that you are conceding that the member did make a credibility finding? That there was a positive credibility finding in this case about Mr. Barbosa's
No.
evidence?
No, Justice Cameron. That
Oh,
was my second point, which I was getting
Okay.
to. If that's okay with you, I can.
Yes, sorry, continue, Counsel.
Thank you.
But before you go there, just to be fair to the RPD, the credibility issue is not only on the transcript, but it's also on her own testimony in the family law proceedings and her inconsistent statements in her testimony before the RPD.
Well, Justice Regiment, right now my submission is regarding the transcript evidence and regarding her alleged consistencies in the family law proceeding. My co-counsel talked about that, and our position is that those inconsistencies were not material in order to say that she was not credible. But moving on to Justice Cameron's question, the RPD member preferred the testimony in the transcript over the viva voce testimony of the respondent because they said the testimony by Mr. Barbosa supported his credibility because no credibility findings were made and his claim was denied solely on state protection. Justice's reasonable inferences are legally valid. That is true. But inferences must be based on facts. There is no clear evidence here which supports the contention that because no credibility findings were made, it means that Mr. Barbosa's credibility is established. This is a clear logical fallacy wherein the RPD member's proof does not support his conclusion. And according to Vavilov, reasons are irrational and incoherent if they exhibit clear logical fallacies. Therefore, it was unreasonable to assert that the refugee hearing of Mr. Barbosa supports a positive credibility assessment. Another reason why we argue that that the weight that was given the transcript was unreasonable is because the evidence, the transcript evidence was not and could not have been properly tested by cross-examination. The RPD regarding this made two findings. First, that this transcript was sufficiently tested as the minister and the board member were present to cross-examine the testimony of Mr. Barbosa. Second, the respondent and her counsel could have compelled Mr. Barbosa to appear as a witness and therefore cross-examine him pursuant to Rule 45 of the RPD. Regarding the first finding, justices, that the minister and the board member were present to cross-examine and that is sufficient, this simply goes against Section 170E of the IRPA, which states that the RPD must give the person and the minister a reasonable opportunity to question witnesses, so both. The federal court in Maganza and Canada provided a list of factors on how to determine credibility. One of those factors is bias, interest, and motivation to be untruthful. The counsel and the respondent not being able to cross-examine and thus challenge the abusive ex-husband's testimony, which contains bias and motivation to be untruthful, goes against 170E.
Counsel, can you explain to me how they were unable? The lawyer and the client made a strategic choice to argue that it should all be inadmissible and not accepted. Is there evidence that they also, in the alternative, asked for an opportunity to cross-examine and were denied it?
No, Justice Penty, that is why this admission of the transcript was so problematic. It's not that our client does not want to transcript this, that our client does not want to test this evidence. We do, but we have to be cognizant of what will happen if our client faces her abuser. We submit that the chairperson guidelines that I just cited, when the federal court in that case stated that RPD violated one of the principles when they relied on the husband's testimony. We were put in an impossible situation that even though we wanted to test this evidence, we could not, and we can't just simply say that we can just compel him to come and testify, because this will really, our client will face major psychological issues when this happens.
Okay, thank you. So it's a practical impossibility you're talking about.
Yeah, practical in the sense that we cannot simply ignore what our client will face, will suffer, and we can't just just say that we could have just called Mr. Barbosa. That is our submission. Yes, as I was mentioning, justices, it is true that just because a witness has self-interest does not mean that their credibility will be impacted. We agree with this statement, but the court considers a couple of considerations for this particular statement. And one of those is the author a close family member, but as a witness, nonetheless is able to speak independently to the event. Mr. Barbosa, the abusive ex-husband, is unable to speak independently to the event. As Justice Okoro explained at the federal court, it is apparent that he had a direct interest in having his version of events accepted, such that his family would not obtain refugee protection in Canada. Regarding the second finding, which I already addressed when I answered Justice Penty's question regarding Rule 45, again, the respondent did not make an application to compel Mr. Barbosa as a witness because she would have to have faced her abuser and therefore suffer severe psychological turmoil. Just be cognizant of my time. I believe I have enough time to continue. Another reason why we submit that the weight that was given was unreasonable is because the RPD member did not fully consider that domestic violence issues in Brazil are seen as a real issue. The potential impact on the respondent returning to Brazil was not sufficiently considered. The RPD member failed to consider and apply the case law, which asserts that the conditions of the country of the claimant must be taken into account. Justices, Brazil consistently ranks as one of the most dangerous countries in the Americas. And we cited a report in our factum at paragraph 26, which states that Brazil continues to be one of the most dangerous countries for women. And despite there being some legislative advances, the reality of women facing violence does not reflect those legislative advances. And the guidelines assert that when making, yes,
sorry, may I interrupt? Are you suggesting there's an alternative ground apart from the abuse, because based solely on gender? Because the member found that the allegations were not credible with regards to Mr. Barbosa's abuse.
Could you clarify your question, Justice Cameron?
Well, what is the relevance of the situation in Brazil if she's not actually facing domestic violence as the member sought? Right? The member's finding is that these were not credible allegations. What does it matter how bad the country is?
Well, because Justice Cameron, our client asserted that Brazil, the situation in Brazil is really bad for women who face domestic violence. And by putting so much weight on this transcript and not considering the country conditions in Brazil, which the guidelines mandate the decision maker to do, by doing this, Justice Cameron, we submit that because they did this, the potential impact on the respondent returning to Brazil was not sufficiently considered.
Counsel, sorry, I just want to make sure that I'm understanding correctly, though. Absolutely, if the member had found that she was a victim of domestic violence, then the circumstances in Brazil for victims of domestic violence would be clearly highly relevant. But if the member has found that she's not a victim of domestic violence, if that is the finding of fact that the member has made, why is the situation of victims of domestic violence in Brazil still relevant?
Justice, the reason for that is because even before admitting this evidence, the RPD member had this information in his hand, especially when the claimant asserted this issue. So yes, as you suggested, they found her not credible. So why does this matter? But we have to go back during the admission of this evidence, because if they had considered this fact, the potential weight that was given in this case might not have the substantial weight that was given, and they gave this weight because they did not consider this potential issue in Brazil.
So counsel, I'm sorry, I just need you to connect those dots for me. So the fact that there is a dangerous situation in Brazil for women who are victims of domestic violence, how does that help this claimant to establish that she is a victim of domestic violence? In other words, how is it relevant to the question of the admissibility of evidence in her case, even before engaging with her evidence? If I know nothing about her case other than this is the basis of her claim, I haven't yet decided that she's not credible. If I understand that the situation is very bad in Brazil,
yeah,
please just tie that for me.
I understand. So our submission is that when the RPD member decided to admit this evidence, during that he had this information that our client stated that the situation in Brazil is really, really difficult. So once he admitted this evidence, he did not. When he admitted this evidence, he did not realize. Because he admitted the evidence, they gave substantial weight to the evidence, but during the admission, without considering this situation in Brazil, the potential impact on the respondent returning to Brazil was not sufficiently considered. So without considering this and admitting the evidence together, it increased the chance of the respondent returning to Brazil. And because later on they gave substantial weight to this evidence, this situation only worsened for our client.
So counsel, I'll just jump in and maybe take this in maybe just a slightly different direction. So the respondent was facing a series of very difficult choices in this hearing. We can all acknowledge that. That's already been acknowledged by all sides. Faced with a prospect of having his evidence be given some weight, was it not either her or her counsel's obligation then to explore alternatives with the RPD so that there was an opportunity to test? Some of my colleagues have already raised examples. So she says she's facing a horrible situation because she's a victim of domestic abuse. Brazil won't take it seriously. She's going to be subjected to it again. She's faced with having to confront her abuser. That's a horrible situation. There are alternatives. It's not the only circumstance in Canadian law where victims face difficult situations. There's all sorts of accommodations laid out. It's not an exercise of imagination.
Yes.
Without having, it's not that the RPD was faced with that and refused it.
Yes. So my response to that question would be, as my friend stated, the RPD, they're the masters of their own procedures. That means when they are in a hearing, they are in control of the procedures that occur. We have to understand the context here, Justice. Our client did not speak English. She was facing a really tough time in her life. And if we look at the RPD member's decision, they made no attempt to explain what kind of accommodations that was available. Yes, she had counsel, that is true. But the RPD member, they're the ones who are the onus are, so they are the bounds who are bound by the chairperson guidelines. And those guidelines state some of the accommodations that the RPD member can offer. But in this case, the language that was used by the RPD member, especially at paragraph 21, they say that any potential concern about juxtaposing the alleged perpetrator and the alleged victim is outweighed by the high degree of relevance of the information. So, and also they also stated that cross-examination was not necessary. So with all this language combined, the RPD member did not attempt to explain any of these possible accommodations that were available. So that would be my response. And I am out of time, so if the court would allow me to conclude. Thank you. Honorable Justices, the respondent's chance to escape her abusive and fearful life is at stake, and the well-being of her children is hanging in the balance. It was unreasonable to admit the transcript and the unsolicited evidence. But even if the court finds that the admission was reasonable, it is our submission that the substantial weight that was given to both the transcript and the unsolicited information was unreasonable. Thus, the respondent seeks the Crown Court of Canada to dismiss the appeal and uphold the federal court's decision to remit the decision back to the RPD for reconsideration. Thank you so much.
Thank you, counsel.
Thank you.
Before I close the hearing, this is the opportunity for feedback from the judges.
I would like to make a 5-minute reply.
I'm so
Is that-
sorry.
Thank you. By way of reply, the respondent, guided by competent counsel, is claiming multiple breaches by the RPD board member. Ultimately, it's within the purview and legislative mandate of the RPD to weigh the evidence before it. The respondent is plainly asking for a reweighing of the evidence, despite the respondent, who was guided by competent counsel, chose not to cross-examine. Soloshna and Alexander at paragraphs 44 are very clear in their rulings that the onus falls on the respondent and the respondent alone. Our learned friends claim that Canada must be seen as a country which provides relief to the respondent and women like her, similar in that circumstance. To balance this perspective, citing IRPA Policy 3, it's very clear that the refugee system must also establish fair and efficient procedures that will maintain the integrity of the Canadian refugee protection system. Our learned friends claiming that the RPD member would not have granted cross-examination is entirely speculative. The respondent waived her right to test the evidence and cannot provide conjecture about what the RPD would have done had they applied to test the evidence. Our learned friends then spoke on defining probative value. We would like to note that the RPD proceedings, in the RPD proceedings themselves, evidence is often admitted, and deficiencies go to weight to prevent any undue delay in the inquisitorial proceedings themselves. Probative value is defined as the capacity to establish the fact of which it is offered proof. The RPD guideline is very clear. All of the questions about the circumstances of the evidence and the self-serving nature is entirely vested into questions of credibility and the weight of the evidence. Any and all considerations of this are given to the RPD solely to grapple with. My friends allude 7 minutes of the length of the transcript evidence, but that is simply asking for a reweighing of this evidence. The submissions on how my friends found that the prejudicial effect of the evidence outweighed the probative are again simply requests to reweigh evidence, and Parliament has vested power within the RPD only to make those determinations. The level of omissions found in the respondent's testimonies were not microscopic determinations of her claim, as our learned friends put it. For example, the respondent claimed in an amended basis of claim that Mr. Barbosa would hit the kids if they were crying. The respondent then later stated that Mr. Barbosa threatened to throw a child out of a window while it was crying. These are severely different statements and significantly shift the risk of assessment pursued under Section 96 of IRPA.
Counsel, I'm just wondering if you're going over the boundaries of a regular reply.
I will align to that. Ultimately, in one breath, the respondent is claiming that the evidence from Mr. Barbosa is unreliable and must be tested. They then proceed to state that the sole testing method they believe to be reliable, if used, would hurt the respondent. But if the RPD knowingly disregards probative evidence, this would impugn the purpose of the RPD and bring the administration of IRPA into disrepute. This concludes the appellant's reply.
Thank you.
now the floor is yours, judges.
So court is closed officially?
I will close the court after the feedback and.
Yeah, okay.
Okay.
So I guess, look, to start, on behalf of all of my colleagues, I want to thank you all for this. How many moots have you done today? I've lost track now. You've done one already today?
I think I've lost track too, but I think we've done one today. Yeah.
One today. So thank you for seeing it through to the end of the day. We haven't rehearsed this in advance in terms of how we want to give feedback. Does somebody want to start, or shall I lead off, and then we can go from there?
Sorry, just to intervene, Justice Penty. We're running quite short on time because the closing ceremonies are coming up.
Okay.
And so we're wondering if we can go directly to the deliberations at
Sure.
this time, and then
Yep.
the feedback will be provided to the students subsequent
Yep.
after the deliberations, if that's okay with everyone.
Absolutely. Yes. It lets us all off the hook so that we can actually think a little bit about what we want to say. You all did very well. It's one comment I would make. Thank
Very
you.
well. Okay.
So-
I agree. Very good presentation.
Absolutely.
So
So I take it we deliberate without the council? You know, it'd be
Yes.
a new innovation in the Crown Court too.
We've changed things a little. Yes, we're just at this time, the registrars are removing everyone from, hopefully anyways.
Yes, so the special sitting is now closed, and we ask that everyone, including the council and observers, disconnect. And if you need any help, I can help disconnect you.